Standing in the community is that if they say it's so, then it's so. That's the wrong thing. You know, it's almost like a dictatorship. You know, when you go into the grand jury and you're not a lawyer, but you're making a decision on somebody's life based on what the state's attorney told you. And as people in the community, you want to believe that these people that you make sure get paid every year through your taxes are doing the right thing, but they're not. They're doing the thing to promote their jobs, you know, to find, you know, some of them. You got some state's attorneys will fight against something that's not lawful. You got some that just say, hey, I'm just here to convict. You know, just as you have some lawyers that say, yeah, I'm here to fight for you, or I'm just here to get paid. So you have it, and
it is difficult because, like I said, you know, like the prosecutor, you know, with his professional career, you know, ethically, his job is to protect the community, and his job is to convict anybody who is arrested, regardless of the evidence he has. And when people think that way, how can you undo the injustice?
District attorneys who see an innocent person and they know that person is innocent and they are honest enough to say that I'm not going to pursue this case because this person is innocent, versus I know this person is innocent, but maybe I can get them to plea out to some kind of deal anyway. You know, that idea or that mind frame needs to change.
This took me over 7 years to compile. During these 7 years, my post-conviction was amended several times, and during this time, Debbie Reinbold, the mentally ill woman, Darrell Harrington, the town drunk, had recanted numerous times in front of a federal court reporter, under oath and on videotape. Well, before I could get a hearing, and an evidentiary hearing, and put this evidence before a judge, they would recant their recantation because this prosecutor and these two dirty cops would lean on them, threaten them with perjury, threaten them to charge them with the murders because Debbie Reinbold had entered into a blind plea agreement. The plea agreement stated very specifically that she was to say what her initial statement was, that she was at the crime scene, and if she did not, further charges would be forthcoming. So in other words, she had to say what the prosecution's script was. And even the judge had a problem with that plea agreement.
I used to be very bitter at her because I considered her as a friend at the time. And I couldn't believe that she got on the stand and lied on me, which I understand why she did it. Because when she went to visit the victim in the hospital, she got arrested, and the detective in the state threatened to take her daughter and her son from her. They took her story because she the first person said I was the shooter. The state and the detectives try to take her kids. She got, like, when she was at the hospital visiting the victim, they found dope on her. She was never charged due to the fact she made a statement against me. So I messaged her on Facebook, told her I don't hold no grudges. I forgive her. May God bless her and her family. Now, I am not gonna lie. At one point in time, I was very upset with her. I pray for her now.
And the way we have the system right now with the police and law enforcement and everything, you're going to have certain problems. And we are unforgiving of somebody who doesn't find the killer of a child. And so we place on them this expectation. They have to find him, and they have to find him now. And that puts a pressure on them to get somebody now. And so part of it is society. You know, it's the whole idea of presumption of innocence.
Under the law, technically, you know, the attorneys don't vouch for their witnesses, except when the state stands up and says, the state of New Jersey calls their next witness, you know, Officer Smith. The jury sees that this is something the state is showing us, and we're going to believe it. And then when it comes to the defense turn, the jury's already heard all this plethora of horrible evidence against the defendant. They already don't believe what they're going to hear from the defense attorney, and then they come in and say, the defense calls, you know, Sonia Smith, and they just, you know, she doesn't carry the same, you know, credibility that the state's witnesses do. So you end up with this really unfair playing field where the state's witnesses are getting a whole lot more attention, believability from the jury, and the defense witnesses are just out there to try to beat the case.
My conviction was overturned once again, third time, and the state's attorney knew that I didn't do this case. He knew I didn't do this case, but he refused to just drop all the charges against me. So John came and saw me that Friday. I was going to court the following Tuesday, which was the October 30th. And John said, hey, this guy brought you a plea, the Alpha plea. He said, as your lawyer, I gotta tell you everything that applies to this plea. He said, as your friend, I want to fight. You know, he said, but I got to give you the law the way the law states, right? And I said, okay. So me and John sat there while we talked. We went over everything. So that weekend, I prayed faithfully. And I asked God to give me the answer. I didn't have the answer Friday. I didn't have the answer Saturday. I didn't have the answer Sunday. I didn't have the answer Monday. I didn't get the answer to that day when it was time to walk over to that courtroom, because truthfully, I did not want to take that plea. I did not want to take that plea. But my mother, when I looked at her face, when I walked past my mother, she said, baby, I need you home. She said, I need you home. She said, we need you. I lost 13 family members while I was gone, immediate family. 13, I got one grandparent. I lost numerous family members while I was gone. And to go through that and not be able to be there, not only for your family that's still here, but not even be able to go to the funerals or nothing, it's indescribable. And once again, it made me fight harder. Because I said, I'm losing family. I'm steady losing. It seems like every year I'm just getting obituaries in the mail. 2 here, 2 there, 2 here, to add up to 13 family members. And man, it really hurts. And that's what made me fight even harder. I was already fighting, but it was like I went back into training again. It was like, oh, I got to get out of here, you know, and
the petition took years, as happens with all these cases, took years to wind its way through the courts. The issue ultimately that was raised on appeal was whether or not his lawyer had rendered ineffective assistance by not calling one of the witnesses who said, no, Anthony didn't do it, he was at another place, this other man did it. And the Illinois Appellate Court said yes, there had been ineffective assistance, and ordered an evidentiary hearing in the circuit court. Our office and we partnered with a local public defender to do an evidentiary hearing, at which we put on some evidence, and the judge ultimately ruled that yes, there had been ineffective assistance, and ordered a new trial. And so Anthony then was faced with a decision of whether or not to accept what came next, which was an offer from the prosecutor to plead guilty in what's called an Alford plea arrangement, ALFORD plea arrangement, by which Anthony could maintain his innocence in front of the court and everyone else, yet plead guilty to a lesser offense. He pled guilty to the lesser offense of second-degree murder, and then literally walked out of prison the next day. What's very telling about that arrangement is that the prosecutor is faced with a decision of, okay, here's a man who's in prison until 2043, another 31 years, but agrees to let this person walk out of prison with 31 years left on his sentence if all he says is, okay, I agree to plead guilty, maintain my innocence, but I agree to plead guilty to this offense so that I can walk out tomorrow. It's really perverse. That offer plea is very controversial at best. I'm glad that it was available for Anthony to be released because he's innocent and because it was time for him to go home, well past time. But it really is perverse when a prosecutor says, we think that you did this to the extent that we insist on you entering a plea, yet we're going to allow you to go home tomorrow. Which is it? You know, is he a killer and he should stay in prison, or are we going to let him go tomorrow? And so it's the ultimate devil's compromise. I'm glad it got Anthony out. In a way, it really hurt, and I know it hurt him too. It really bothered me. But as a lawyer, I know that it's his decision. It's not my decision. My job is to answer his questions and to render whatever professional advice and information that I can. But ultimately, any plea decision is the client's decision. So I had to keep most of my thoughts to myself as Anthony made that decision.
Wouldn't let go of the conviction, and they offered Anthony an Alford plea, which essentially meant that Anthony wasn't admitting guilt, which he would never have done, but that they would release him for from his sentence as time served. He served 14 years for a crime that he didn't commit. So he had about a week to decide what to do. If he would have not accepted the plea and gone for another trial, it would have been at least a year down the road, and another, risk. And he asked John Hanlon, our legal director, and myself on a daily basis during that period what to do. And, we told him that it was his decision and that we couldn't make that decision for him. Personally, I just wanted him to get out of Menard. There had been, from the time that the evidentiary hearing to the time he was released, there were 4 inmates murdered at Menard. It was a very risky environment for him to be in. So he ended up taking the Alford plea. But since that time, he's had a terrible time trying to get employment because he's still a convicted felon. So even though he's out, in some ways, he's still in prison. He's still on parole. He still has to meet those, all the things that are required of him on being on parole. But he was able to spend time with his grandmother, who has since passed away, and with his mother, who also has health issues.
I know that they don't want to admit they're wrong because maybe someone will file a lawsuit and maybe someone then will have to pay, and we all don't want to pay. In Illinois alone, taxpayers have paid over $250 million for wrongful convictions. We all know we don't have the budget for this kind of thing. But it's okay. We all make mistakes. And of course, you're in the criminal justice system. It's a human system. It's not a machine. It doesn't stamp them out, spit it out. This is a human machine. There will be failures. It's really okay. I think the rest of us have to encourage people to just, maybe we need to be kinder or not so brutal with people who do admit they're wrong. But that has been my biggest frustration, is just seeing time and again people who don't want to say, I might have made the wrong judgment call at that time. And that's all it is. You're a human being who has a really hard job. So that is my frustration.
One thing the whole community and the legal system needs to keep in mind that the leading causes of wrongful convictions are prosecutorial abuse and eyewitness fallibility. And I don't know of very many cases where prosecutors that have been held accountable. And even Santiago's case, they still think he's guilty. The system is not set up to, they're not willing to admit their mistakes.
For this prosecutor to admit that he prosecuted the wrong person, I mean, here's this man, he offered me both trials, 20 years due 10. He has to say she's the right person, or else he's admitting I didn't go ahead and follow up on the obvious leads we had, which resulted in a little girl getting raped and killed 2 days later, and several other girls getting raped and killed. It's my fault that that happened, partially. I share that responsibility. He can't do that. You know, society doesn't really allow prosecutors and detectives to make these kinds of mistakes and feel okay about it. You know, we don't have a place for that to happen.
I think what surprised me the most was the unwillingness on a lot of prosecutors to engage in the process early on when contacted about a new case that's come to light and trying to work out testing agreements and things like that. I really was surprised by how much static and sort of delay we got from a lot of prosecutors. I have seen that change somewhat over, when I look back, I started as a student 9 years ago, so I'm almost a decade into at least having exposure into the work, not as a practicing attorney the entire time, but, and I have actually, it depends on where you are, but there is some forward movement on some prosecutors' offices, which is really nice, but that was shocking to me. I think even my first year of law school and obviously everything leading up to that, there's such a sense of faith and trust in prosecutors and believing that they all are out fighting and, fighting for the truth and for justice. And a lot of them are, and that can't be, understated or overstated. There's a lot that are, but those that aren't really do muck up the process. And I found that really troubling. A lot of different prosecutors' offices have a big choice to make right now, and it's either acknowledging that the wrongful convictions have happened and that, the wrong person's been convicted in a lot of cases. And so prosecutors have a choice. You can acknowledge that and be on the right side of history and decide to do the right thing and be willing to look back at old cases, and when a lawyer approaches you, be willing to discuss it and potentially do testing. Or you can be on the wrong side of history and you can fight and not acknowledge it and let these people linger in prison. And what I've seen, which is really promising to me in the cases that I've been working on in Illinois, is that at least 2 of the counties that I work in, the prosecutors recently have such a willingness to talk about these cases and to engage in the testing process. One of the counties, they've even hired former lab analysts to work in their office, and then they can do really, really detailed analysis of evidence and decide what could undergo DNA testing and what would be probative towards innocence. And that just makes a world of difference. I mean, I look back at cases I've worked on and where you've had a prosecutor agree to testing immediately, that process happens really quickly and they have nothing to lose. If you really are fighting for justice and you want to do the right thing and you conform with the model rules of professional responsibility, which for 3.8, rules of prosecutors requires that you're there to do justice and not just obtain convictions, then what do you have to lose? When an Innocence Project lawyer, any lawyer, approaches you and says, we want to do DNA testing, we think this person may be wrongly convicted, we will pay for the testing, just go to the judge and tell them that you don't oppose it. Like, what do you have to lose? But so many people, don't do that. But so what's promising to me is I think that my experience has been, at least in some of these counties in Illinois that I've been working in, it's getting better and they're more willing to talk about cases. There's a lot of places where they're not, but you can see the difference. I mean, look in Dallas, where the DA took over and he created this whole unit to examine wrongful convictions, and they've had a ton of exonerations. And that's a good thing. I mean, no one wants to like be the county that has had the most people wrongly convicted, but I mean, people pretty much have to acknowledge this happens everywhere all over the country. And so to be a county where you're getting a lot of exonerations means that you're listening to people, you're willing to compromise and to at least engage in the process. And then once the science shows you what the truth is, you acknowledge it and you let someone go on to live their life. So I'm hopeful that things will move in the right direction. My fear is that there are some prosecutors out there who just want to explain away the science. And so you have cases that come to trial today, so not even addressing old convictions, but current cases where they may find DNA in a particular, scenario, and they'll find a way to explain it or not present it to the jury. And, so they minimize the impact and the importance of the DNA in order to sort of prevent DNA testing later to be this powerful, earth-shattering, thing that turns over a conviction.